Welcome. I'm Andres Mecher, a New Jersey immigration attorney with offices in Long Branch and Lakewood. Today, USCIS is publishing their final rules for what they are now calling the Provisional Unlawful Presence Waiver. I just finished a teleconference with DHS Director Mayorka and a representative of the Department of State, and I couldn't wait to talk to you about it. So in this video series, I'm going to describe to you what the program is, what the requirements are, and I'm going to define some of the terms so that you understand what this program actually is. So come on, let's get to it. Alright, the purpose of this video is to define what is unlawful presence as it is used in the Immigration Naturalization Act, and more specifically as it's applied to the Provisional Unlawful Presence Waiver program that's going to become effective on March 4, 2013. Now, the Immigration Naturalization Act defines unlawful presence as someone who is, quote, present in the U.S. after the expiration period of stay authorized by the Attorney General, or is present in the United States without being admitted or paroled, end quote. So basically what that means is, if you were allowed to enter into the United States, let's say you were a student visa, let's say you're a tourist visa, you had a tourist visa, B1, B2. You entered into the United States, you were admitted, you were allowed to stay for a certain period of time, let's say 6 months, and then you stayed beyond that time. The day after the authorized stay lapses, if you are 18 years or older, you will begin to accrue unlawful presence. Now, the other circumstance is if you entered into the United States without being admitted or paroled. So if you crossed the border, for example, through Mexico or through Canada, without being admitted, without being inspected by a CBP agent, you begin to accrue unlawful presence the first day that you're here. Now, this only applies to people who accumulated presence after April 1st, 1997, when these requirements came into effect. But let me give you an example where unauthorized time does not have any consequence against you. Now, as the rules state now, if you've accumulated 6 months or more unlawful presence in the United States, when you leave, you will not be able to return for 3 years. If you accumulated more than 12 months of unlawful presence, when you leave, you will not be able to return for 10 years unless that unlawful presence is waived through a program like the one we are discussing here. But what happens if you come in as a tourist, you stay for 179 days, and then you leave? Then you return to the United States, again as a tourist, again overstay by 179 days, and then leave. The automatic bar will not prevent you from returning, even though you've overstayed by almost a year in 2 separate circumstances. Now, the reality is, if you overstayed by 179 days, the Department of State may not issue you another visa. But the point of it is, if it did happen, and if you were back, you would not be subject to the automatic bar, and you most likely would not need this program. The Provisional Unlawful Waiver program will only forgive unlawful presence. So if there are other actions or other waivers that you need, you may not qualify for this program. Also, keep in mind, you cannot apply before March 4th, 2013. So beware of notarios or immigration consultants that say otherwise. For something as detailed as this program, you absolutely have to speak to a qualified immigration attorney. You do not want to find yourself outside the United States when you first learn that you will not be able to return for 10 years and will not be able